Good afternoon. Just a few items before we start. At the end of the presentation, we'll be sharing a QR code with a link to both presentations. Both Phil and I are going to speak, so you can download the presentation. Second, we ask that you hold both of our presentations are interactive, so there'll be audience participation, but we do ask that you hold your questions till the end, and we'll have a Q&A period. Who had one of these? Yeah? Lots of hands? At its peak in 2010, BlackBerry had over 40 million users worldwide, 43% of the North American smartphone market. A cultural phenomenon, they could not possibly fail. Except they did. Apple launched the iPhone in 2007. BlackBerry's founders publicly dismissed it. They didn't see it as a threat. Within 3 years, it was over. BlackBerry couldn't see it coming, but afterward, everyone said it was obvious. And why do I bring up BlackBerry today? Well, partly because we're in Kitchener-Waterloo, and it felt appropriate, but also because it ties into some reading I've been doing lately on this concept of risk. I give risk management advice to architects, but that term, risk management, has always felt a bit like an abstraction. We hear it all the time in the insurance world, in the financial world, but what does it actually mean for architects, and how do we even begin to think about it? In 2007, Nassim Taleb published The Black Swan. Taleb was an options trader. Now he's one of the world's leading thinkers on risk and uncertainty. Taleb defines a black swan as an event with 3 features. 1, it's unpredictable. 2, it has massive impact. And 3, and this is the important one, after it happens, we convince ourselves we saw it coming. Daniel Kahneman, a Nobel Prize-winning psychologist, said this book changed how he sees the world. Kahneman had already spent decades changing how our brains are wired to see patterns, even where there are no patterns. So show of hands, how many here have been involved in any way in a legal claim at some point in either your career or your personal life? Okay, lots of hands. So my question is actually for those of you who did not put your hands up, and that is, why do you think you've never been involved in a claim? And if anyone is brave, you can shout out some ideas. Go ahead.
Because I had a father who was a lawyer.
Awesome. Good. Anything else? Good luck. That's a good one.
I'm a great architect.
Okay, so here's some reasons that I hear from architects. And I hear one of these things more than any other, and it's that last one that Eliana helped us with. I'm a good architect. And think about whether that resonates with you. Here's another book. In 2018, Annie Duke published her book, Thinking in Bets. Duke was a professional poker player turned business strategist. Her argument was simple, and that is that we tend to judge our decisions by their outcomes. And she argues that outcomes are actually a terrible way for us to judge decisions. Here's how that might play out for architects. You've never been in a claim, and maybe you've never even had an unsuccessful project, and you think, I'm a good architect. Oops, that's skill. Or you have been in a claim, or you've had a series of terrible projects, but you think, bad luck. That's chance. So good outcome, we take personal credit. Bad outcome, we blame the circumstances around us. But Duke says that both of these are wrong. Duke says that we should think like poker players. a great poker player actually expects to lose a certain percentage of hands. They don't take it personally, but instead they plan for it within their strategy. They have a process in place before they sit down at the table. The statistics tell us that most architectural practices will face a claim at some point. For larger firms, being in a claim might be a regular occurrence. And I think we may be in one of the riskiest professions out there in terms of litigation. Every building is unique, the market's volatile, the technology is changing, new codes, new materials, new delivery methods. Risk is baked into what we do. And being smart, or even just being a good architect, doesn't mean that you're making good decisions about risk. NASA has some of the smartest people on the planet, but the night before Challenger launched in 1986, their engineers warned that the O-rings in the shuttle could fail in cold weather and advised against the launch. Their management overruled them. Why? Because the O-rings had shown problems on previous flights and nothing bad happened. So they normalized the risk. After Challenger, NASA completely overhauled how they make decisions. Part of this was instituting structured processes to purposefully bring dissenting opinions to the surface and giving them weight. What NASA learned is that good decision-making is a process, not a personality trait, and not a measure of intelligence. This idea is now being taught in courses at places like Harvard University. I haven't been to Harvard personally, but I think we already know this in architecture. The Salk Institute didn't happen by genius alone. It happened because of rigorous processes, in this case, in design. The question I keep wondering is, can we apply that same discipline to how we manage risk? This year's conference theme is collaboration, so I thought we'd look at risk through the lens of the people who we collaborate with the most, and arguably the people most associated with claims, and those are our clients. Clients are unpredictable, and it's hard to design processes around what you can't predict. But, and this is totally unscientific, I realize that there is a certain cast of characters that we tend to see over and over again in claims. Borrowed from a certain paper company in Scranton, Pennsylvania. So first we have Michael. I'm so excited about my first project, Scott. Ryan, what if we just value engineered the whole thing, Howard? Jan, I'm not going to compromise on the vision, Levinson. Toby, I need to run this by the committee, Flenderson. And Pam, you can trust me, Beasley. So let's start with Michael. Michael's a first-time developer, very excited, eager to make easy money. He just found out that he needs an architect's stamp for his permit application. He's never worked with an architect, and he doesn't know much about the profession, but Michael knows that he's paying, so he expects the architect to do what he says. So we have a lot of collective experience in the room today. So let's have a show of hands on how successful your Michael projects are. So top third, so that's 67 to 100% are successful. Show of hands. I see one hand. Anyone for the middle range, it's a coin flip. Few hands, and then and then never again. Okay, lots of hands there. So here's what we see in claims. Michael is most likely to, number 5, is that working? Not pay for proper due diligence like site review and third-party inspections. Number 4, make unauthorized changes on site to the permit drawings. Number 3, threaten, bully, and feel wronged. Number 2, fire his architect or create conditions where the architect feels they need to quit. And number 1, stop paying the architect's invoices, then justify it by saying they made errors and omissions. So in the interest of time, we're going to focus on number 1 today. Here's a typical Michael claim. It was a new auto repair shop, no formal contract, hourly fee arranged by email. The owner stopped paying. The architect kept working for around 4 months. When the architect started asking for payment, the owner turned verbally abusive, accused the architect of making a structural decision 6 months earlier without their approval. The architect then resigned and filed a lien against the project. The owner retaliated with a lawsuit for 5 times the amount of the lien, claiming the architect's decision had caused rework and delays. So let's brainstorm. Any ideas for risk management measures that the architect could have taken before they agreed to take on this project? You can just shout them out. Contract, yeah. Anything else? Big retainer, okay. I didn't hear that one. Letter of credit, okay. Interesting. Anything else? Okay, so here's some that we came up with. Due diligence on the client. They could have checked references and the client's financial background. In this case, the owner had a history of verbally abusing people they worked with, which the architect found out afterwards. Number 3, they could have checked the budget and timeline were realistic. In this project, the schedule was never really realistic and it was never going to be attained. Number 2, they could have had clear non-payment terms in their contract and followed through on them immediately when they weren't paid. And number 1, they could have been more careful with hourly fees. This claim had an inexperienced client with no understanding of what budget to carry for the architect's hourly fee work. And then when reality set in, they simply stopped paying them. Okay, we're going to move on to Ryan. Ryan is an experienced developer of condominiums. He works on big high-rise developments, lots of money at stake, lots of players. Ryan is very familiar with the construction industry. He cares about design, but only so far in that it helps him sell condominium units. And when he asks for something, he expects it done fast. So how successful are your Ryan projects? Top range, anyone? Yeah, Alex? Middle? Okay, lots of hands. Bottom? A couple hands. I think most of us can probably agree that Ryans are usually better to work for than Michaels. They're more experienced in construction, they're less emotional, more predictable, but not necessarily for your insurer. Ryan projects are actually our biggest source of claims, and those claims usually come not from Ryan himself, but from the condominium board years after the architect has completed their contract. So from Pro-Demnity's perspective, Ryan is most likely to, number 5, expect and pay for minimal drawing sets and shop drawing reviews. Number 4, suggest substitutions and expect you to agree to them. Number 3, expect your insurance to pay for every error you make during construction. Number 2, have leaky buildings. And number 1, Ryan is most likely to not correct Terrian deficiencies in a reasonable time frame. So we'll focus on number 1. This is a case study. The project was a new condominium in Ottawa. The architect was retained through a fee proposal letter. During construction, they performed regular site reviews, relying on the contractor to document any deficiencies. They reviewed shop drawings, but they relied on the contractor to circulate them. The building was occupied in 2019. The architect had no involvement after occupancy, not asked to do deficiency reviews, not copied on performance audits. In their mind, the project was complete and it was the perfect project. But then 6 years later, in 2025, they were served by the condominium corporation with a claim for building envelope failures and water infiltration. The developer was also named in the same claim, but the developer had since gone out of business. So these condo claims usually come out of nowhere, and risk management for them may simply mean planning for the worst from the get-go, that the project is eventually going to end in litigation. So with that in mind, any ideas on what the architect could have done when they were setting up and working on this project that would have helped with their risk management?
We follow up on the warranties after they expire.
Follow up on warranties? Okay. Yeah. Anything else? Don't work for developers? That's a good one. I like that one. Okay, so here's some that we came up with. Have a well-written contract and keep good records. In this case, the architect only had a fee proposal letter and produced no site review reports, even though they were on site bi-weekly. To remember to keep pressing that button. Number 3, be explicit about what's not in your contract. Here there was an envelope engineer, but nothing in writing about how the responsibilities were divided between the architect and the envelope engineer. Number 2, check that the submittals have adequate detail and are stamped. In this case, the relevant shop drawings the architect sent us had no stamp from the trade engineer, the contractor, or the envelope consultant. And number 1, don't sign any closeout documents for services you did not perform. Moving on to Jan. Jan is a lawyer who just bought a house in Rosedale with her husband Michael, who is also a lawyer. She wants to tear the house down and build a new, bigger house, and it needs to impress. Jan is super busy with her professional career, but she's confident she can juggle both her job and the house construction. She's been very clear that the job needs to be built for exactly $1.5 million and not a penny more. So we're going to vote again. How successful are your Jan projects? Top range, anyone? No one. Okay. Middle? Yeah, I see some hands here. And bottom? Okay, this is the most, I'm surprised by that, actually. I was going to say, I think some people like working for Jans because they usually have money to spend and they can be fun and profitable projects. But Jan is also very similar to Michael in a way because she's usually inexperienced in construction and emotionally invested in the project, and that can lead to issues. So from Pro-Demnity's perspective, here's what we often see with Jan claims. Number 5, Jan is often a lawyer or married to one. Sorry, Phil. She may see litigation as a normal way to resolve a dispute. Number 4, she's busy with her career, so decisions on finishes and materials drag out. Number 3, wealthy neighborhood, wealthy neighbors, and they will sue over construction impacts to their own properties. Number 2, Jan realizes late that the project has gone over budget and suddenly everyone's to blame. And number 1, Jan is very likely to get into a dispute with her contractor over quality, cost, or schedule. Here's a Jan claim focusing on that last one. This claim was a luxury single-family passive house in the GTA with a budget of $1.6 million. The architect verbally gave their client 3 contractor names for the work, and the client chose the contractor with the lowest budget pricing, ignoring the architect's concerns about that contractor's budget being too low with no breakdown. The owner entered a cost-plus contract with the contractor, again against the architect's verbal advice. During construction, COVID hit. The owner made design changes. The contractor had deficiencies. Costs kept going up and up. The owner eventually fired the contractor and sued them. The contractor then filed a third-party claim against the architect. The architect was blindsided. They had done everything right, and up until then had just been trying to mediate the situation between the two parties. So, okay, now in these claims, the architect tends to get caught in the crossfire in a dispute between the owner and the contractor. So with that in mind, any ideas on anything the architect could have done to prepare for that? That's a good one, I like that one. Document their objections. Anything else? Yeah?
Give advice on contracts.
On contracts?
Yeah.
Or, okay.
Make sure I get lawyers' advice.
Yeah, good one. Okay, so here's some that we came up with. Put your concerns in writing. This architect had concerns about the contractor's budget, their schedule, and their contract, but they didn't put them in writing. When giving names of contractors to your clients, document the limitations in writing. Don't frame them as recommendations. Number 2, if the contractor is pricing from incomplete drawings, document that. Consider getting a waiver or indemnifying yourself. In this case, the contractor never properly priced the work, even when they had complete drawings, and that was the core of the dispute. And number 1, notify the owner in writing when their own actions may cause a delay. Here, the owner made a major design change during construction, and that was also a big contributor to the dispute. It was from the client that the price they were getting from the contractor was based on incomplete drawings. Yeah. Moving on to Toby, I need to run this by the committee Flenderson. Toby is an in-house project manager for an institutional client. Toby is responsible for soliciting and finalizing direction from various user groups who are all pretty slow at making decisions. He comes from an engineering background and has a good understanding of construction. So how successful are your Toby projects? Top range, anyone? Yeah, see a few hands. Middle? The most hands, okay. And then bottom? No, I don't see anyone. Okay. Yeah, so I think most of us probably feel that Toby projects, which usually have a traditional project delivery method, are seemingly safe clients. But these are also often very complex projects with big budgets where the architect has the most involvement. And that can sometimes lead to large value claims and complicated claims. So from Pro-Demnity's perspective, here's what we see with Toby. Toby retires mid-project, and his inexperienced replacement has no background on the project. Number 4, when the contractor submits a delay claim, Toby engages the institution's in-house lawyer to rebut it, and things escalate very quickly. Number 3, the contractor whispers in Toby's ear all the things the architect did wrong, and he starts to believe them. Number 2, Toby hates dealing with his own procurement department, so work like investigative test demolition gets lumped into the main project. And number 1, Toby has to run every change order by a finance committee, and the committee thinks that the architect should pay for some of them. And again, we'll focus on number 1 today. This claim was a hospital renovation, a recurring client. Their contract had 27 pages of supplementary conditions. One of those conditions made the architect responsible for the consultant's errors. Another gave the owner the right to claim back for construction cost increases. During construction, an existing slab condition was different than was assumed, and it ended up being a 6-figure structural change order. The project manager who would have understood the issue had just retired, and a brand new project manager stepped in and proceeded to issue a notice of default to the architect. Then they just stopped paying them. The notice of default references the supplementary conditions that we talked about. So any risk management ideas on this one? Don't accept the contract. I like that one. No comment on that one. Anything else? Okay, so here's some we came up with. Don't accept unreasonable supplementary conditions. This architect didn't expect them to be a problem, but they were. Understand or notify the owner of gaps in existing building documentation. In this case, the risks of unknowns weren't spelled out in writing to the owner. Check that cost estimates and contingencies reflect the work. Higher unknowns mean higher contingencies. The owner needs to understand this. And number 1, bring demand letters to your insurer before you respond. This architect came to us right away, and we were able to help them. Okay, here's our last client, Pam You Can Trust Me Beasley, representing our repeat clients. Pam is the stalwart that keeps coming back to your firm and gives you repeated business. So how successful are your PAM projects? Top range, anyone? I think we'll see a lot of hands here. Yeah. Middle, one hand, or maybe a couple. And bottom? None. Yeah, I think for most of you are in the top range. PAM projects are probably your most profitable and reliable work. But that trust itself is also the risk. When things go well for a long time, we stop doing the things that protect us. So from Pro-Demnity's perspective, PAM is most likely to, number 5, expect efficiencies in cost in drawing production and architectural construction services. Number 4, similar to Toby, lose institutional knowledge when a long-term employee leaves. Number 3, take an abrupt change in direction when new management or new leadership arrives. Number 2, not sign a contract because we trust each other, don't we? And number 1, use the relationship as leverage when there's a dispute. So instead of giving you a new case study for PAM, I'm going to go back to our Toby and Ryan examples. Both Toby and Ryan were repeat clients. In both examples, the architect trusted their clients to treat them fairly and keep proper records. But unfortunately, trust is not a risk management strategy. So any ideas on risk management strategies when working with PAMs? No, not hearing any. What was that?
Put everything in writing still, like your 4 clients.
Yeah, put everything in writing. You got it. So here's the ones we came up with. Use rules-based logic when insisting on contracts. I know it seems unnecessary because we've worked together for so long, but we have an office rule. We won't start working without a signed OAA contract. It's out of my hands. Number 2, don't assume that standards and procedures carry over from past projects. Put everything in writing. Number 3, keep your own records. Don't trust others to keep them for you. Time and time again, an architect being sued hasn't kept important records because there was this relationship of trust and they thought someone else was keeping them for them. And number 4, contact Pro-Demnity before trying to settle disputes to preserve the working relationship. Okay, To tie everything together, BlackBerry had the smartest engineers in the room, NASA had the smartest scientists on the planet, every architect in our case studies was a good architect. That wasn't the problem. The problem was that they didn't have a process in place for what they couldn't predict. You can't predict how a Michael will behave. You can't prevent a Ryan claim from landing 6 years later. But you can have rules in place before you sit down at the table. Process-based rules aren't about avoiding risk. They're about taking the right risks confidently. If the contract isn't fair, you can take the risk of standing your ground. If you or your colleagues are being treated poorly, you can take the risk of speaking up or of walking away. If you are passionate about the environment, you can take the risk of rejecting work with no environmental objective. These are the risks that advance your career, that grow your business, and that allow you to bring your own personal principles and passions into your work life. They aren't always limitations, they are the things that give you power. That's it for today. Thank you, everyone. Thank you. And I'll hand it over to Phil Ghosh.
Okay, so here we go for part two. Who here has seen one of my previous year's presentations? Hands up. Okay, so for those of you, there will be a bit of repetition, but I've added some good new nuggets as well, just for part one, legal concepts, which is where over the course of 15 minutes, I teach you how to be your own lawyer. I'm just kidding. That you should never be your own lawyer. And then we'll rush through to part two, which is the fun part, where we'll go through some case studies with obviously the names anonymized to protect those involved, and what lessons we can learn from some of these lawsuits that we've dealt with here at Pro-Demnity. Okay, so before you can actually sue someone, anyone can actually sue anyone for anything in Ontario. So you don't actually need to have logic behind your claim, and this is going to be one of the themes that sort of comes out of this talk. You can get sued whether it's a good claim or a bad claim, but then it gets worked out in the legal system. But for it to be a good claim, a claim with merit, a claim that Pro-Demnity might put money towards to settle or that a judge might accept at a trial, you need to have what's called a cause of action, something that actually grounds the right to bring a claim against you. And so potential causes of action against architect can be for breach of contract. They can be for negligence, which is the main branch of tort law. They can be for negligent misrepresentation, which is a subset of that I'll explain later. And then we sometimes see people argue that an architect has breached a fiduciary duty, although I have yet to see that argument actually succeed. So we won't go through that in too much detail. And each of these causes of action developed over time through the common law. Canada's law is based on the British system, so it's inherited law that precedent after precedent is built up over hundreds of years, dating back to the Magna Carta or possibly before, so 1,000 years. But a lot of it has been subsequently codified in legislation like the Negligence Act. Okay, so what does someone need to prove a claim of negligence against an architect or against anyone? There needs to be a wrongful act or omission. Something wrong has to be done. That act has to have breached the standard of care expected in the situation. So just doing something wrong is not enough. You have to do something that didn't meet the standard that's expected of you. And we'll talk about that more in a second. There have to actually be damages. Just because you've done something wrong, if you actually haven't caused any harm, then there's no reason to sue you. There has to be causation, which means that the wrong that you did has to be linked to those damages. And there has to be a duty of care. It has to be to someone to whom you owe a duty. Now, in the case of an architect, you will owe a duty to most end users of your building, as well as your clients, as well as other parties working on a construction project, so that's not much of a hurdle. Okay, so what is an architect's standard of care? This is what you have to meet to avoid liability for negligence. An architect is to exercise the reasonable skill, care, and diligence expected of a reasonably competent architect performing similar services on a similar project at the time of the project. An architect doesn't have to be perfect. You don't have to do what the singular perfect architect might do on a project. It's okay to make mistakes, make typos, make larger errors. But a court will look to what that reasonably competent architect working on a similar project would have done, and they'll look to expert evidence on industry practice to determine if you've met that standard. So in addition to an architect, negligence claims can involve all sorts of parties that might not have met their own respective standards of care, their own duties owed in the circumstance. So in a construction project, that can be anyone else involved in construction. It can be other consultants. It can be construction managers, general contractors, subcontractors, municipalities. But depending on the type of lawsuit, it can also be other parties involved later on. It can be occupiers, owners, and tenants, property managers, end users, the people responsible for the building over time, because something arising much later might have a maintenance component. And it can be the plaintiffs themselves. The people suing you sometimes are the ones that are actually the most at fault. They just don't recognize it. Okay, contracts. What is a contract? It can seem obvious, but sometimes it's important to go back to basics to understand whether you have a contract or not. And so a contract is an offer that is accepted and that has consideration passing from one side to another. So you can offer to do something, the other side can say yes, but that's just a promise. But when there's money exchanging hands, I'm going to provide my architectural services in exchange for this fee, that's a contract. Okay, so what is breach of contract? So it's great to say I have a contract. Why do we care what are all of the terms in a contract? At the end of the day, if someone's not going to abide by the contract, is it worth the words that it's written on? The reason why we care is because theoretically you can go to a judge and have the judge apply those terms or grant damages for breach of contract. So breach of contract is when a breach of a term of the contract has occurred. Someone hasn't followed what is written in that contract. Not only have you not followed what's in the contract, but it's actually caused a loss. So again, you need damages. And in the architectural case, let's say your fee proposal says you'll do site visits monthly, and there's a month where you missed a site visit. Well, that's technically a breach of contract. But let's say there was no work being done on site for that month. So technically you've breached the contract, but you wouldn't have caught anything had you even been on site. So there were no damages. So someone can't sue you for breach of contract because there's no loss caused by that breach of not showing up that 1 month. And then the damages have to be within amounts prescribed by law. It can't be unconscionable. If you have a client who says, for every time you don't appear on site, we're going to charge you $1 million, that might be considered unconscionable. Okay, moving on to negligent misrepresentation. So as I said, this is a subset of negligence, so the other factors of negligence also apply. But negligent misrepresentation specifically applies where you have a special relationship between someone who says something and the person who hears it. So it's all about a representation. And it has been found that professionals giving advice to clients does create that special relationship that can ground negligent misrepresentation. When you make a false or misleading statement, and the making of the statement was negligent, so you should have, if acting reasonably, not made that statement, and the person on the other side relied on that statement, and they relied on it to their detriment, that's when you have negligent misrepresentation. So what we mean by this is if you're telling, so let's see, does anyone have, just shout it out, anyone have an idea of when negligent misrepresentation might apply to a client, to an architect? Okay.
It'll only cost $100,000.
Thanks for helping me out, John. Okay, so the two main scenarios where we see this is you told me that that a reasonable project budget would be $200,000, and the project budget ends up being $500,000 at the end of the day. Well, the owner is going to say that was a false or misleading statement, and that they wouldn't have started the project had they thought the budget was different, so they relied on it. The other main situation where we see it is, you told me that X contractor was going to be a good contractor. I relied on you. You told me that this subconsultant was going to be a good subconsultant. I relied on you. So that's where we get into negligent misrepresentation. Okay, so what even matters if you are found liable? Well, that's when you could be paying damages. So let's go back to the basics. What are the damages that you could owe for a wrong, be it breach of contract, negligence, negligent misrepresentation in a lawsuit? Well, damages are to put the plaintiff in the same position they would have been in had the wrong not occurred. So had the breach of contract not happened, had the negligence not happened. And this could be very different depending on the circumstance. It could be the cost of a change order that resulted directly from a design error. It could be the cost to repair a problem discovered post-construction. Let's say there is a leak in a building. It could be the cost of remediating that sort of damage, or a fire. It could be the cost of remediating that damage. It could be the diminution in value of a building. And in the case of personal injury, which architects do get sued for when people trip or injure themselves otherwise, it could be a whole range of things, of lost income and medical expenses to put someone in the life situation they would have been in. Vicarious liability is another risk for architects. What it means is that at law you can be responsible for the negligence and breaches of others. And so I've put the two sort of most basic examples of this. A parent is responsible for what their children does. Employers are responsible for what their employees do. And also, if you're someone who is hiring a subconsultant and bringing them to a project, you can be vicariously liable for what the subconsultant has done. Now, where that subconsultant has their own insurance, at the end of the day, there's something called apportionment, which a court will look at, well, who is more responsible if more than one person is responsible? Okay, is my mechanical engineer more responsible for the mechanical design error than I am for having brought them to the project? Yes, and so the mechanical engineer will be the first one to pay for their error. But what happens if that mechanical engineer is bankrupt and has no insurance? Then it doesn't matter that they're more responsible because you're also responsible. That's when you're on the hook. So that's why vicarious liability matters. So at the end of the day, what happens if you get sued? Well, you report it to Pro-Demnity, and we try to resolve the case. 98% of cases resolve prior to trial in Ontario. Why is that? Partly because our court system is so backlogged for civil cases, which I could do an hour-long presentation on alone, but it takes 3 to 7 years to get a case to trial. Even knowing that most cases settle, we still have to act in every case as though it's going to go to trial and defend you to the best that we can. But there are various off-ramps in that sort of 7-year period, and a case can settle at any one of them. At the pleading stage, which is sort of the written fight, it can settle at mediation, it can settle at pretrial, it can settle at the trial door. Okay, let's move on to our case studies. Okay, so this case I'm calling the Forest Hill case. It didn't actually happen in Forest Hill. It happened in another similar rich neighborhood, but it was a multi-million-dollar custom home in an exclusive neighborhood with a highly fenestrated design. The homeowner was a tech millionaire. He was very particular. He was an engineer himself. It had a project budget of about $6.5 million, and the HVAC budget within that was $900,000 just for the HVAC. This owner wanted to control temperature throughout the house in each room separately to a 0.5 degrees Celsius range. But yet, as the house was actually built, on peak summer days, it couldn't even cool to 20 degrees, let alone have that variation. The architect was the one who recommended the mechanical engineer, and in that recommendation, he mentioned that, yeah, this is the engineer that worked on my own home. So here are my questions to the audience. What do you think, and we'll reveal the answers on the next slide, what do you think was the cause of action against the architect here? We'll see who was listening. We hear misrepresentation. Anyone, anything else? Okay. Who do we think was most at fault for this? Okay, I'm hearing mechanical engineer. You get bonus points if you get it right, so the points are not worth anything. But what do you think were the approximate damages in this case? So I'll run through and put up your hands when I reach the number that you think is correct. The damage. Sorry? So this was settled, so we'll say settled for. A, $0. B, $10,000. C, $50,000. D, $300,000. E, $900,000. Okay, we've got a smart crowd because the answer was D, $300,000 were the approximate damages. The actual value was a little more than that, $317,000, because we also owed some legal expense. Who was the most at fault? Yes, it was the mechanical engineer in this case, but this case settled at a pretrial where the judge had a very strong opinion that the architect was also to blame for not properly communicating some of the implications of the mechanical decisions to the client, and the architect had the more proximate relationship with the client. I'm not certain that argument would have won at trial, but it is a factor that you have to consider when a judge is telling you that. So Pro-Demnity contributed 12% of that $300,000. And what is the cause of action? This was a trick question because you can have more than one. So negligent misrepresentation was definitely one, so that was great. But it also was breach of contract for the architect not following the duties that the architect owed in the contract, and it also was argued that the architect was negligent in their coordination with the engineer. Okay, so rapid fire round. I'm just going to take us through a couple fact scenarios quickly, and I'd like you guys to tell me what subconsultant do you think was involved, was the party that was more likely at fault. So sprinkler pipe burst case, a pipe froze in winter during the retrofit of an office building, the heater in the room where it froze did not activate because of the failure to install a thermostat. What subconsultant got the architect in trouble here? Yeah, electrical engineer is correct, but I heard electrical and mechanical, and so those are both great answers. Slip on an uneven sidewalk. A plaintiff suffered a broken hip tripping on heaved stones on an exterior paved sloped walkway. Any ideas? Yes, landscape architect. Landscape architect was responsible there. Okay, falling millwork case. The plaintiff suffered a concussion while eating at a steakhouse when wooden millwork fell and struck them on the head. Who was responsible for specifying that millwork? Any guesses? In this case, it was the interior designer. High-rise redesign. The podium space in a building was redesigned to incorporate more office floors. During construction, it was discovered that the foundation level structure couldn't support the additional load. Okay, it was right there, structure. Yes, structural engineer in that case. What are the lessons learned here? Subconsultants can be a liability risk to architects. You can be vicariously liable for their work or liable for failing to coordinate or communicate with them. And so what should we do if you include subconsultant services within your scope of work? Use a contract. And it's not a mistake that I put it twice, use a good contract, because if you use the subconsultant's contract, it will often include terms that protect them and don't help you. So I'd recommend using the OAA 900 or something similar to it. And verify that they have adequate insurance. Innovation, and you'll see that was the collaboration cases. These are the innovation cases. To match with our conference theme, we can see the dark sides of the collaboration and innovation. That's how you can tell I'm a lawyer. The innovation case was an avant-garde home. The client wanted a modern, cutting-edge home. The architect met with a supplier and specified use of a fiber cement board for the first time on this type of project. Or the first time ever for this particular fiber cement board, which was fairly new to the market, had only been in Ontario for less than 2 years at the time it was specified. The photos show a couple of the issues. You can see the cracking and you can see the fading of the panel. There was an installation guide that was a translation to English from Italian. The translation was done by the supplier. The project was only the supplier's second or third time supplying this for a private residence, and a Korean-speaking subcontractor installed the materials. What parties do we think were at fault here for the damage to this cladding? Any brave souls? Yeah, okay, so we hear the architect a little. Anyone else? Okay, we'll see on the next slide. We'll put your hands up here for A, B, or C. How should the damages be measured? Should the damages be the cost of the material? Should the damages, in this case, by the liable party, what they have to pay to this homeowner, be the cost incurred to reclad the home? Okay, a lot of hands. And should it be something else? Okay, we've got a couple something else. It's a trick question because that's what I do. It's something else. But it's basically the cost to reclad the home. The home was, in this case, actually reclad with a masonry product that costs a lot more than the fiber cement board. And so the damages were what the cost would have been to reclad it in a similar fiber board. Because to make them right, to make them in the situation they would have been had the fiber board not failed, you would put on a similar fiber board. You wouldn't put on a nicer masonry product. Which parties were at fault? There were a lot of problems here. The supplier who prepared the manual, the contractor who didn't properly instruct the subcontractor on how to install the board. As it turns out, the cracking was because of improper placement of screws and over-tightening, among other issues. And had the actual manufacturer instructions been followed, that might have been resolved. So the subcontractor for not installing it correctly, but the architect as well for specifying a material that, without doing appropriate due diligence and without making sure that the mock-up was appropriate to the manufacturing guide. The reason why I put manufacturer question mark is because the fading, which was a separate issue, the counter-argument was fading of this material is a feature, not a bug. So whether or not that's true. So here are some lessons about innovation. We're not saying don't innovate in terms of your materials and your design, but definitely perform appropriate due diligence before you specify a material that's new to you. Make sure the contractor is up to the task. Make sure the manufacturer's installation guide is available, and don't prepare your design with conflicting detail. Just understand that innovation is riskier, so be ready to increase your level of diligence accordingly. Water. This is just to hammer home the point that water claims are some of the most common claims that we get here at Pro-Demnity. So I'll read out 4 little fact scenarios, and 2 of these Pro-Demnity did have to contribute to a settlement, and 2 of these we did not. So that will be our game: is which 2 did we contribute to, which did we convince the other side to let us out for $0. So another spring pipe burst. We have a pipe that burst in winter in a banking pavilion that was under construction, but the heating system was already turned on. Insulation was blamed. Pipe dreams. We have water supply pipe to a generator room on a roof that also burst in winter due to a failure of heat tracing and insulation where the pipe was exposed. When it rains, it leaks. We had stormwater in a condominium. The stormwater drainage pipe from the roof failed, causing water to leak into units below. And we have brown water, which was a sewage backup incident because the sanitary line was wrongly connected to the storm line, which didn't work out well at the next storm. So do we think A and B were the cases that the architect got out? We've got 1 for A and B. Do we think B and C? We've got 2 for B and C. Do we think C and D? We've got a number for C and D. Do we think A and D? Okay, so it was C and D. The condominium and the sewage backup we were able to convince in both of those cases. In the condominium case that it was the mechanical designer, and in the sewage backup it was clearly the mechanical contractor. The other 2 cases, there are the arguments about the insulation and how that related to the pipe bursts created a bit of exposure. So water is definitely an area rife with failure, be it rainwater, subsoil, sprinkler supply, drainage pipes, condensation. In my experience, most of the water claims we get involve a mechanical engineering scope. That is the most typical claim, and we do a good job of defending them on the basis that they are mechanical, not architectural. But the areas that have more architectural risk are cladding, roofing, and insulation detail. This slide, for those of you that had seen John's presentation, it was also in his. This is just to show you that water damages on the right side there are one of our largest claims, and also to kind of hammer home the point that there are so many different types of projects and different types of issues that can lead to an architect getting involved in a lawsuit. But recognizing this is very small, I'll move on, and you can see our annual report if you really like the data. Okay, and here are some oddball cases, and I'd like you to all, in the spirit of being taught to be lawyers over the last 20 minutes, think creatively and think why it is that the architect might have been, why it's argued that the architect did something wrong in these cases. Okay, so in the semi-detached nightmare, a neighbor sued, a neighbor of the architect's client sued the architect, the contractor, and the neighboring homeowners for damages to a common wall, dust, and raccoons in the attic. Why are they arguing that or what are they saying the architect did wrong? So someone brave over here is saying something? So that actually is a fact that came out in the case, that the common wall didn't go all the way up to the attic, and that's how the raccoons were getting across. But the argument that was leveled against the architect is, you didn't get my permission before you started designing this. So is there a legal obligation for an architect to get the permission of someone on the other side of a semi-detached wall? Actually, no. But you can be sued for things that there's no legal obligation for you to do. It's reasonable to rely on your client to deal with their neighbor, so long as your design should be sensitive, but that's not for you. A sled makes for a sorry home. The foundation design did not take into account soil conditions properly, and a home was slowly sliding down a ravine lot. Why was it argued that the architect was at fault here? Yeah, and so the architect retained the structural, so didn't get a soils report is what we heard. The architect retained a structural engineer who didn't get a soils report, and so it's argued that the architect was responsible for that error. Okay, a very secret project. The client hand wrote a confidentiality clause into the architect's standard agreement saying that the architect would keep their work on this project completely confidential. This project was a custom single-family home to be built on a lot that, as it turns out, was directly adjacent to that client's ex-wife's home. And when the ex-wife found out about the project, he sued the architect. So why was the architect blamed here? So the answer is that the client believes that the architect told the ex-wife about the project and that there was a breach of this contractual term put into the contract. So this is just to illustrate, you can act reasonably. Like who would envision this? Maybe it's a bit of a red flag when someone is handwriting a confidentiality clause into your contract. Maybe you should ask why. But I sympathize more with the architect for not maybe seeing that risk. And this is a lawsuit that's been going on for years and may go on for years more. Home is too short. So designs were prepared to maximize, to build a home to the maximum building envelope allowed in the zoning. And in fact, there had been a zoning amendment, minor adjustment just to get this zoning. But the homeowners then brought a claim against the architect when they realized that their home would not be the tallest on the street. Why was the architect blamed here? Okay, so this one actually is a bit of a better cautionary tale. The architect was blamed because on their elevation, they showed not to scale adjacent buildings that were shorter than the home. Now, we did manage to get out of this for $0 because what are the damages when the client has specifically signed off on building it exactly to this design, and the only thing they're saying is, well, I wanted mine to be the tallest on the street, what are the damages? So we were able to get away from that lawsuit. But again, just going to show that anyone can sue for anything at any time. So coming off of that depressing note, here are some five best practices that I would encourage you to follow. Always have a contract with your client, a written contract, because if you just have a handshake agreement, that still is a contract, but a court will decide what the terms of the contract are rather than the written terms. So you always want your written, signed contract with a client. Always have a good contract with your subconsultant, not their contract, your version of a contract. Keep records of your site visits, your meetings, your client instructions. Stay within the scope of your services. And most importantly, report your claims early to Pro-Demnity because we are here to help you and we will help you navigate all of these situations. That's what we're here for the profession. So that's the main portion of our presentation, but we would welcome any questions. It's something you should It's something you should ask for, yes. Now, insist, of course, if they say no, you don't really have much choice but to abandon the project if you think it's that important. Whereas when it's your own subconsultant, you have a little more leverage because you can say, well, I'm not going to hire you without insurance. But yes, you can and should ask for their consultants to have insurance.
Could you put it in your contract with your client that they have to have, that he has to get that?
Yes, you could, yeah.
I think it is in OAA,
In the standard,
OAA
yeah.
600. I could be wrong, but I think it might be in there.
Oh, so, at the back here? What happens to subconsultants that don't have insurance? They hope that they never get sued. But the answer is it depends, which is a favorite lawyer answer. But if they are sued and they are at fault, they could hire their own lawyer, or they could, if they're a corporation, they could render their corporation bankrupt, or maybe the lawsuit will render it bankrupt. So, subconsultants are best served to have insurance as well.
Unless I'm missing something, but earlier in the slide, in order to have a contract in place, you have 3 points: an offer, acceptance, and payment.
Yeah.
And if there's no payment, then there's no contract.
That's correct. Yeah. So if you have all the terms of your contract in place, but the fees never flow to you, any fees don't flow to you, then the contract is null and void. But if some fee flows to you, the fact that they didn't pay all of it is a breach of contract, but the fact that they paid some of it is enough consideration to say there is a contract.
What kind of claims have you got related to owners, subconsultants? Like, are there any cautionary claims about that?
Oh, yes, absolutely. All the same. In fact, some of the stories that I put up would have involved owners, subconsultants as well, because anything that can go wrong on a building does go wrong. Yeah.
But architect's responsibility is just for coordination, right? They're not responsible for it.
Correct. So in that case, your risk of exposure is less because it's just coordination. But what that coordination duty entails could depend on the circumstance. And even again, if you're less responsible or less likely to be found responsible at the end of the day, you still might be in the lawsuit for a bit until that's determined. But for example, those water cases where I said we got the architect out of the lawsuit early because it was the mechanical engineer's responsibility, those were cases where the owner had retained the mechanical engineer, and we were able to make that case that, look, there was no coordination issue here, so that's what helped get the architect out early. Yeah. At the back?
Touching on the same point about the coordination, like it's a very well-known law, like architect responsible for all the coordination. How would you kind of differentiate between the consultant doing their job and our responsibility of coordination? Let's say they do zone and they mix between both of them.
Yeah, so coordination actually really depends on the circumstances of the project and what your contract says your coordination will be, whether you're coordinating with other consultants or whether you are coordinating the duties of the other consultants, and there's been case law on this. So an architect with the duty to coordinate merely with the other consultants, really it's a duty on both sides to make sure that there aren't interferences between the architectural scope of work and that consultant's scope of work. Whereas if you're coordinating the duties of the other consultants, there might be a more proactive duty for you to make sure that all of the consultants are properly coordinating amongst each other. But in coordination cases, there can be an argument of an error on either side of that coordination relationship, even though the architect is usually held to sort of be the one that sort of leads that process. Sorry?
Is there like an industry standard or something written, like what is the limitation of the coordination?
That will be set out in your contract. Leslie, any thoughts on that?
Yeah, I agree. It should be set out in your contract, and we encourage you to use standard agreements. And if you are not doing all the services in the standard agreement, if you're not responsible for coordinating the consultants, then that needs to be amended in your contract.
We're often prime consultants.
Yeah.
Is that, presumably that would increase one's exposure in a contract like we're
Yes. Yes, so the question is, we're often prime consultants, does that increase your exposure? It increases the likelihood of exposure, like I was saying before, to the vicarious liability for others, if by prime consultant you're saying that you're the one who's hiring the others. Prime consultant is one of those terms that's thrown around that people in the industry tend to understand, but there usually isn't actually in any given project any term in a contract that defines this is what prime consultant means. So it really sort of depends on the circumstances. If you're hiring the other consultants, then you'll have more exposure. If by prime consultant you mean you're the first one who was brought on the project and has the closer relationship with the client, that's also something that, you might have more duties to inform the client of what's happening in the project, and that can increase your exposure as well. So what you mean by prime consultant sort of depends on what the extra exposures are, but yet, as a general rule, I would say yes, those are the cases that creates more exposure. Not a reason not to do it, but a reason to be aware of the risks. Cynthia?
Regarding our responsibility to condominium boards and owners later, I once read some case law where the developer had a clause in the purchase agreement between the developer and the unit owner to limit their warranty to 2 years for everything in the building. And I wonder if that was a thing that could occur in law in Ontario, just that having that clause in that purchase agreement.
Sorry, can you kind of repeat it? So there's a clause in the agreement between the developer and the purchasers.
The purchaser of each unit, there was a clause that just said 2 years.
That the warranty will be only 2 years. I don't see any reason why that wouldn't be enforceable in Ontario, that the developer would only be responsible for ensuring a 2-year.
That is, you have to comply with the carry-on.
Oh, yes.
There is different warranties, years for every assembly, so you can't override the law.
Okay, no, I agree with you. So yes, you have to comply with carry-on regardless.
Right.
And the,
Other things
yeah,
that carry-on wouldn't wear.
yeah.
Or other future things.
Then also the contracts also have a warranty, like 2 years minimum. So you also have to.
I'd have to read the case to know the specifics.
Aside from the last slide with those kind of bullet points of the takeaways, is there any further advice you could give to an intern that's just starting their career in architecture?
Yes, well, so I think Leslie had a lot of good advice in her deck as well, actually. I think that aside from what was there, those are the basics, and that's why I put it there. Documentation is really key. Getting a good written contract that's signed by your client is key. Documentation throughout the throughout a project is really important. And then for an intern architect, I would just say rely on the resources that are out there. We have a risk management department at Pro-Demnity that where you get into a situation where you're worried about a risk you're taking on, they will give you advice, and Leslie is one of them. And there are practice advisors at the OAA as well, and go to your peers, and just be conscious that there is risk out there. Don't act as though, don't get frozen in terror by the risk, but just be aware of risk. John, do you have? I'm seeing John is shaking his head. So Schedule G is something that is very problematic because it is written in a way that encourages project owners to get architects to sign it. But the way Schedule G is written, and it is written that way because of legislation, it's written in such a way that creates a lot of risk if you sign it as an architect that we normally wouldn't want you to take on. So, my favorite answer of what to do with the Schedule G is to try to get an engineer to sign it instead, because they're allowed to. But yeah, I'm not sure about progress with Terry on it. It is problematic, so it would be great if someday there could be. Yes?
Yeah, I think just to add to that, I did mention Schedule G on one of my slides, but the point was, if you are going to sign it, only sign it for the work that you did. If you didn't do envelope inspections, then don't sign a Schedule G saying that you did that. Or I see a lot of architects signing Schedule Gs for mechanical engineering work and structural engineering work. So you need to avoid. Just sign it for what the architectural, if you are going to sign it, just for the architectural. It's wishy-washy. Yeah, it is. Yeah, and I think that was one of the case studies that I presented because the project keeps going. A lot of architects, your involvement ends once you get occupancy, and then deficiency work continues on as the performance audits come in, and then the claim arises from that, which the architect has no involvement in because your involvement ends at the Schedule G point. And so, I think anything where your services end, if that's clear in your contract, that's only going to help if these sorts of claims arise. Like if you're not involved in those finishing deficiency works, then say that in your contract. I think you're very smart to get the indemnification.
Well, and that is the problem that we see is that architects get pressured to sign it for exactly that reason. Yeah, go ahead.
So I'm Bruce Palmer. I'm the CEO of Pro-Demnity. We've talked with the OAA. We've talked with everything. We
willing to work with their lawyer. The problem is, if all architects would ask for that, that would be easier for me.
Yeah.
I would
Any architect, right?
I agree with you.
But some architects are just signing them because every new client I have is like, somebody asked me to sign them again.
We agree with you. We agree it's a problem. If we have the power to fix it, we would fix it. There seems to be a level of understanding but no burning desire to do anything at the government level. And I'm not trying to dump on the government, but on their list of priorities, this just isn't there.
Well, then we need to educate all our architects, not
Well, and hopefully those in the room are hearing this and maybe taking note. And I think the precaution that you're taking is a very smart one. Another precaution is where you're signing the Schedule G and any portion of it to maybe append a letter or handwrite in what are the things that you're relying on for as your basis for, well, then maybe append a letter to it. It's a.
provide a sample letter to us? I know you can't be legal counsel.
No.
But we sign a sample letter. Indemnification.
So the difference between the technical requirement schedule and the Schedule G is, the Schedule G is a legislative requirement. So, we can't not cover every condominium claim, then, that would be problematic. Whereas the technical requirement schedule is actually giving back coverage. It is covering water ingress claims where they meet certain best practices. Okay, next question. Let's move on from Schedule G, not because I don't think it's a problem, but to give others a chance to ask their own questions. If there are any other questions.
It's all Schedule G.
Okay, well, and any thinking back to Leslie's presentation, any questions on the various office characters of the world?
I'm wondering if there are any safe clients that wouldn't draw a claim.
Thank you, Eliane. No, there's no safe clients, only safe practices and safe procedures. So I think it's about what you can control, which is your procedures and strategies that you put in place, and the office rules that you can have before you start in the project, so that you can apply those when any situation arises. Thanks.
Okay, well, thank you everyone for listening, and we'll be at the Pro-Demnity booth through the end of the conference.